Hi, it's Craig Pollard from NBIA, and today we're talking about the family and domestic violence leave provisions that have been inserted into the Fair Work Act. We'll get to the commencement provisions. But just so you know, if you're a large employer, and that means you employ more than 15 or more staff, I'm sorry. So if you employ 15 or more staff, these provisions commenced in February, from the 1st of February. If you're a small employer, they commence later in the year. So we'll get to that in a minute, but just so you know, if you're a large employer, these provisions apply to you right now. Okay, so family and domestic violence leave was introduced by the Morrison government, the Labor government late last year. And the leave has been around for a while. There's a number of provisions that are exactly the same. But previously the leave was unpaid and it was only for 5 days per annum. What they've done is they've made the leave 10 days per annum and it's now paid. And so we're going to be going through all of those provisions and how they impact you and what you need to prepare for. So the Fair Work Act, as I just said, has increased from 5 to 10 days and that leave is now paid. Here's a summary of the entitlements. So they're now entitled to 10 days paid family domestic violence leave, and I'll refer to it as FDV leave from now on, per annum. The entitlement doesn't accrue. Okay, so what that means is it's not that this year they get 10, next year they get 20 if they haven't accessed it. It's 10 days per annum, no matter what. And in that regard, it's very similar to how compassionate leave works. The accrual date resets, or sorry, the entitlement date resets on the anniversary of either of these dates. If you're a large employer, the 1st of February, and if you're a small employer, so 14 or less employees, from 1 August 2023. Now, if you're a large employer and you've got an employee that's just commenced today, then the 12-month commences from today for that employee. Again, exactly the same way as it operates for compassionate leave. Okay, so if you've got an employee who was employed with you prior to 1 February 2023, their anniversary date is 1 February each year. If you've got an employee that commenced 1 March this year, then their anniversary date will be 1 March. And it's the same basic principle for the small businesses from 1 August. Employees are entitled to be paid their usual wages, including shift penalties and other loadings during FTV leave. So again, vastly different to any other form of leave. Unlike personal carers leave and annual leave, which are basically calculated on the base rate of pay, this leave, it's what they would have received if they had worked on that shift. So including regular overtime and shift penalties and weekend penalties. Employees aren't taken to be on personal carers leave when taking family domestic violence leave, so you don't deduct it from their sick leave accrual. And they must provide reasonable evidence of the need to take the leave. But you've got to keep this confidential and you're not allowed to share it with anyone unless you're required by law to do so. So for example, if the police come waving a summons or a subpoena in your face saying, we need this information, you must provide it, then you have to provide it. Otherwise, you keep it under lock and key. You're not allowed to share it with anybody. So just as an update on when somebody needs to take the leave, under the Act, they can access paid leave if they experience family or domestic violence and they need support, or they need to access services to deal with the impact of that violence, which is impractical to do outside of work hours. So for example, if they're working 9 to 5, then you can't obviously see a lawyer normally outside of those hours. So they're entitled to family and domestic violence leave to attend legal appointments and court dates and things like that. And it can include making arrangements for their own safety or the safety of a close relative. It includes court appearances, accessing police services, attending counselling, and attending appointments with medical, financial, or legal professionals. So as a summary, right, as a guide, if someone has suffered domestic violence or family violence and they need to see a doctor, they need to access a medical appointment, that comes under family and domestic violence leave, not personal carers leave. Okay. If they're ill because of whatever reason as normal, well then it's personal carers leave. But if they're absent and injured because of a family domestic violence situation, in that situation, then it is FDV leave. Oops, sorry. So what are the actual provisions? So the payment. So if someone is taking a period of family and domestic violence leave, they've got to pay, you've got to pay them for that period for an employee other than a casual employee at the employee's full rate of pay worked out as if the employee had not taken the leave, okay? Or for a casual employee at the employee's full rate of pay as if the employee had worked the hours in which the period employee was rostered. So this is the key difference. Unlike any other form of leave, this applies to casuals too. But casuals are only entitled to be paid if they were rostered to work. So if an employee is normally rostered to work on a day, and for whatever reason they're not rostered to work on say Wednesday next week, Wednesday rolls around, they call in sick and say, boss, I'm not ill, then they only get paid if they're rostered. If they weren't rostered, you say, mate, I'm sorry, but you weren't rostered to work, so there's no entitlement to family and domestic violence leave. If they call in sick or call in because of FDV and they were rostered to work, well, then they get paid what they would normally receive. So, for example, in retail bakeries, if they were one of your sandwich makers and they come in at 5 o'clock, then they get their normal, they're a shop person, they come in at 5 o'clock, then they get their 2 hours at pre-shift overtime, 5 till 7, and then from 7 o'clock they will get whatever they would normally receive at their usual rate of pay, okay? This includes over-award payment. So if you're paying them above the award, then they're entitled to get that above award pay. If is taken to have been rostered the work hours in a period that the employee has, and they've accepted the offer of the work for those hours. So let's say you don't have a printed roster for your casual, okay? But you've said, hey, Wendy, can you come in next week, next Wednesday? Wendy says, yeah, no, all good, I can do that. And then unfortunately, Wendy is a victim of family domestic violence, or she needs to access services associated with family domestic violence. Then she's taken to be rostered to work and she gets entitled to be paid for those hours. And number 3 says, look, it doesn't mean they can't access those services, but you're not required to pay them. Okay, so I don't quite understand why they had to put this provision in, because it just doesn't make much sense. There's not much work for it to do. It's basically saying that if they're not rostered, they can still take family domestic violence leave, but it's unpaid. Well, if they're not rostered and you hadn't offered them work and they hadn't accepted work, well, then they're a casual employee and they're just not working. So I don't quite understand that provision, but I'm sure some lawyer somewhere is very happy that they got paid for that particular paragraph. Okay, so non-small business employees, this is the provision that says it applies from 1 February. I will not bore you with absolutely everything, because as you can see, it's a bit of a word salad. But it's just saying that this is the provision that sets out when it applies from and how the anniversary provisions work. Okay, so again, as I said before, it applies for large businesses, so those that employ 15 or more employees from 1 February, or the employee's commencement date, whichever happens later. Okay. And again, for small business employees, exactly the same, 1 August, or what happens at whichever was last. So that's essentially family and domestic violence leave. As I said, it is accrued, or it applies from the anniversary date of their employment or the anniversary date of the commencement of the entitlement. They get paid what they would have received if they had worked. Okay, it is not payment at the base rate as it is for compassionate leave or personal carers leave. And you have to keep it secret. You're not allowed to include on the pay slips, and this is a very important point, you're not allowed to include on the pay slips family and domestic violence leave. You have to put either approved leave, or you can have a different code for ordinary hours, but you're not allowed to put anywhere that they've accessed family and domestic violence leave. Well, for obvious reasons, if they're a victim of coercive control, then their partner's going to have access to that, or a family member's going to have access to that information, and that could make everything even worse for them. So it's very important that you do not put on the payslip that they are accessing family and domestic violence leave. You do have to record it in your internal systems. My recommendation is that you have ordinary time 1, right, for normal ordinary time work, and then maybe ordinary time L, so ordinary time leave, or ordinary time 2, some other nondescript code that only you know what it actually means, so that you can record that they've taken the leave, and it shows up on their payslip as some other code that is just nondescript, doesn't really draw attention, and nobody's the wiser at home, but you know in your internal systems what's going on. That's pretty much the leave. It's been around for a while. The only difference now is it's paid.